Hi, welcome to another edition of What It Is, a place where we talk about the ways immigration laws affect everyone. Today, we're going to answer the question, what is marriage fraud? Hi, I'm Michael Ruttle, immigration attorney and founder at Ruttle Law PC based in Torrance, California, where we practice immigration law in all 50 states. So what is marriage fraud? It's defined under the Immigration and Nationality Act as a marriage that is entered into for the purpose of evading immigration laws. That's what it is. In other words, marriage fraud is defined as two people getting into a marriage for the sole purpose of getting a green card without having any intention of establishing a life together. The parties have to show that they intend to establish a marital life together. They intend to live together. They intend to plan a future together. If the couple cannot prove that they intend to establish a life together, then by law it's considered to be a sham or a fraudulent marriage. Documentation is very important in marriage-based cases. Things that the government routinely looks at to show that to signal that the parties intended to establish a life together include a lease agreement showing that both parties live together, utility bills showing both names on it, evidence of bank accounts or commingling of finances. Other things that are helpful are affidavits from third parties who can attest to their knowledge of the bona fide marriage. And then the parties are also allowed to include other documentation to show that their marriage is a valid marriage that might be unique to their case. Consequences of a marriage fraud finding can include not only removal or deportation from the United States, but it can also be a bar to obtaining permanent residency or green card in the future. If somebody is removed based on a fraudulent marriage and then they may become eligible in the future in a different green card category, they might be ineligible based on this marriage fraud finding. Detecting marriage fraud is a top priority for immigration officials. They like to routinely cite this survey from the 1980s that supposedly says around 30% of all marriages are suspect for immigration purposes. However, that study is routinely discredited, but sometimes the government likes to rely on it nonetheless. Regardless of what statistics the government relies on, the law is clear that if they are going to accuse somebody of marriage fraud, the bar is very high. The government's evidence must be substantial and probative. Those are two factors that have significant legal consequences and are not easy to establish in any case. If a couple is suspected of a marriage fraud at the early stages of the process, it's possible that when they get to the interview stage, they might be put in what's called a Stokes interview. More on that in a separate video, but generally a Stokes interview is where the government separates the parties in the marriage, asks them the same questions, and then compares the answers to see if the parties really do know about each other and establish a life together. Marriage fraud is a very complex issue, so if you or anyone you know is facing or dealing with a marriage-based green card application process and you're worried about whether you have enough documentation and you don't want the government to accuse you of marriage fraud, contact an immigration attorney at Ruttle Law today to see if we can help you. As we've said, documentation in this case is very important. Hopefully you found this video helpful. If you did, hit that like button, click that bell, subscribe to our YouTube channel if you haven't already, and follow us on Facebook to stay up to date on the ways U.S. immigration laws affect everyone. As for marriage fraud, now hopefully you understand what it is. Until next time, I'm attorney Michael Ruttle. Keep climbing that mountain.